Good afternoon, everybody. Welcome to Bruegel and welcome to this panel debate on the European Data Union strategy and how to write a new rule book for Europe's digital values. As you know, data are a very important production factor nowadays in modern advanced economies. A production factor in its own right and very different from other production factors like land, capital, labor, machines, because data are non-rival. They can be reused many times over. And so access to data and reuse of data and pooling of data become very important issues in our modern economies. And that's why we need data regulation, because there are many potential market failures. Those who sit on the data or hold the data do not necessarily want to share them with others. And so most data regulation is about opening up access to data and trying to overcome data market failures to realize the value of data for society as a whole and not only for the private holders of data. And so the EU and the European Commission has developed and launched an impressive array of data regulation over the last couple of years, starting with the GDPR way back in time almost. But the previous the previous Commission launched a number of data regulation pieces, the Data Act, the Data Governance Act, and a number of sectoral data regulations as well, in the health sector, for example. And there were data sharing provisions in the Digital Markets Act as well. So there are many aspects of data regulation spread out over many regulations in the EU. And for some, this has become a maze, a cobweb that's very difficult to navigate. And especially also because there are many different concepts and definitions of data and procedures and way of accessing the data across all these different tools. So this has become very difficult to navigate. And I think that is why also, well, first of all, in the Draghi report a year ago, Draghi called on the EU to try to simplify these regulations and reduce compliance costs to increase productivity in digital services. And Commission President von der Leyen has taken this to heart. And in all the mission letters to her commissioners, she really insisted on taking these Draghi recommendations to heart and implementing them in their domains. And trying to simplify data regulation is one of those aspects that came in Commissioner Virkkunen's mission letter. So today we are here to discuss what this is actually going to mean in practice. Commissioner Virkkunen announced the Data Union strategy. At the same time, the Commission announced also a Digital Omnibus package that will touch on many of these regulations. And so we would like to see where can we simplify regulation, where can we harmonize and create more convergence. And for this purpose, we brought together a distinguished panel of speakers. First of all, on my left here is Björn Jurecki, who is the almost difficult name. Sorry for that. Björn is the head of data policy unit in DG Connect. And so that's the unit that basically holds the pen for drafting and redrafting all these data regulations. And also his predecessors were very much involved in this. So he's clearly a key person in this. Björn has been in several commission roles in DG Connect. He was assistant to the director. He worked on robotics and artificial intelligence. So he has a wide experience in this domain. We also have Leona King. Leona is at the moment a PhD student at the University of Leuven at the law faculty. She works at CITIB, the Center for IT and IP Law. And she has done a lot of research on data regulation in the EU. And her PhD is also focusing on that subject. And so Leona will bring us a more academic perspective, law perspective on these issues. And then we have Francesco Gersoni, who represents Orgalim. Orgalim is an industry association of manufacturers of connected digital devices. So really the hardware devices that are connected to the internet and that collect data. And of course they are very much involved and very much linked to a number of these data regulations. His organization is not the pure data services part. The Googles and Microsofts of this world are not part of that, but it's really the manufacturers part. And so we would like to hear the industry perspective on data regulation and how this is going to work. For the audience online, we have Slido, and so you can use the hashtag #DataUnion if you want to ask questions, and they will appear on the iPad here in front of me. And we'll try to reserve the last 10-15 minutes of this hour to have question and answer with the audience, and to also with the online audience. And we hope we will have a very fruitful debate and a very lively debate on all these issues. So let me start with Björn. Can you tell us a little bit more about what the Commission has in mind when we are talking about improving data regulation, streamlining it, reducing compliance costs, improving coherence, and how all this fits into the data union strategy that the Commission is planning to launch, and maybe also in the Digital Omnibus package? I don't expect you to reveal all the secrets and to speak before the Commission will officially reveal these instruments and new policy packages, but maybe you can lift some of the veil on that and inform this audience about what we can expect.
Sure, happy to do so. And thanks, Bertin, for the kind introduction and for organizing this session. I would add, though, that we're not only holding the pen for the data policies, but also have access to the shredder, since we're talking about simplification. You know, it's not that we only want to write new papers, but maybe also throw some of them in the bin or shred them. I mean, let me maybe, to start with, take a look back what we have achieved in the past and where we stand now, and then what are the new challenges we see that we have to address in the data union strategy and the digital simplification package. As most of you know, we had already a previous strategy in February 2020, the European Strategy for Data, with the goal of creating a European single market for data. And this was underpinned by two pillars. One was the legislative pillar, and the other one was the innovation and deployment pillar. On the legislative pillar, we created the Data Governance Act, which was about increasing trust in data sharing. So we created in that Data Governance Act so-called data mediation service providers, so neutral data brokers that connect supply and demand, and we have now roughly 20 of them registered in the EU. We also had the Open Data Directive, that's already from previous times, with an implementing regulation on so-called high-value data sets. And in this implementing regulation, we created 6 categories of high-value data sets, geospatial data, meteorological data, that the public sector has to make available for free in machine-readable format. And then the major piece of legislation was the Data Act, which deals with access to IoT data. So it gives the users of IoT devices control over what happens with that data, and the user can also decide to pass that data on to another third party and not necessarily just the original manufacturer. The Data Act also deals with business-to-government data. It's not so relevant now, but at the time we were still halfway in the corona crisis, and we needed that data to also address emergency situations, and now we have put that on a solid legal footing. And the final element is related to cloud. We want a more competitive cloud market, and we facilitated cloud switching and are in the process of abolishing, for example, cloud switching and charges. And even before the Data Act enters into application, which, by the way, is this Friday in 2 days, lots of hyperscalers already abolished cloud switching fees, so we can already see that the Data Act is producing an effect. In the past years and months, the focus was very much on helping businesses to implement the Data Act. So we did a lot of outreach. We organized more than 40 workshops, also with a focus on industries that we normally don't talk to, like the construction industry, railway industry, and so on, because they're all affected by the Data Act. On that basis, we developed a very elaborated FAQ document where we answer the most critical questions that came up in these discussions, and I hope that helps industry as well. We will also accompany the further implementation with model contractual terms and standard contractual clauses that help to set up data sharing contracts, and they'll be published later in autumn. On the deployment side, we have invested a lot of money into these so-called data spaces. I mean, data spaces are technical infrastructures that facilitate data sharing. They also have a governance framework, who can access what data in the data space. We have focused our funding on 14 areas of strategic interest: finance, agriculture, manufacturing, and so on. And these data spaces now are in the deployment phase. Maybe just to mention one concrete example, we've set up a so-called European cancer image data space, and that will have access to around 60 million cancer images by the end of 2026. I think it's immediately clear that not one single member state could set up such a comprehensive database, and it's also very clear what kind of public health and innovation benefits could flow from such a data space. We have invested around 300 million euros into data spaces, with a few hundred million euros still to come in the current multi-annual financial framework. But there's, of course, more to data spaces than our EC-funded projects. There are also lots of private sector initiatives, Catena X, Eona X, and so on. Some of them you will know. Overall, we count around 180 data space initiatives in the EU. Having said all that, the goal was to create this European single market for data, and I think we have to be honest with ourselves that we haven't achieved. Data is not flowing so freely yet. Companies are not sharing enough data yet. And also the world has moved on since February 2020. So there are new challenges that have come up that we have to address. One of them is the emergence of generative AI, which requires different data compared to the more industrial data we focused on as part of the Data Act. There is also concerns about the complexity of the regulatory landscape we have created, also the governance structures we've created. There's overlap, and you alluded to that as well, the interaction between horizontal laws such as the Data Act and more sectorial instantiations, and we'll probably discuss that later as well. And then we're also in a changed geopolitical environment where other third countries are imposing data localization requirements on European companies, and also control the export of sensitive data more, and we have to position ourselves in that context. In the past couple of months, we have again conducted a very comprehensive consultation exercise. There was a public consultation, a call for evidence, and stakeholder workshops. And in these workshops, these 3 problems that I've mentioned were also raised by companies. And on that basis, we are now in the process of working on the data unit strategy, which will be published later in autumn. And it will roughly have 3 pillars that address these 3 problems. So the first pillar is making more data available for AI. I mentioned the Open Data Directive and the list of high-value data sets. So we are thinking of adding new categories to the list of high-value data sets, such as judicial data, to make more public sector data available, but there's a host of other measures, of course. When it comes to simplification, we want to merge some governance bodies. Again, for the Open Data Directive, we have one governance body, confusingly called PSI Group, Public Sector Information, and we have the European Data Innovation Board, which deals more with the Data Governance Act and the Data Act, and we want to merge them into one body. We're also considering making the registration of data intermediation service providers voluntary. Currently, this is mandatory, and this is probably the reason why we only have 20 in the EU. If we take that obligation away, then we hope to see more of these bodies emerge in Europe. And finally, international data flows. So we also need to, look at the outgoing flows of sensitive data and see whether we have to take measures there. And we also want to work more closely with like-minded countries outside the EU to align our positions in international fora such as G7, G20, and UN. regarding the digital simplification package, that will actually be the legislative implementation of what we will describe on simplification in the data union strategy. So, I mean, the areas I've mentioned, but of course there are also additional areas we're looking at, the Data Governance Act, the Free Flow of Data Regulation, and others. Maybe interesting to know that the digital simplification package will also launch yet another public consultation exercise and a digital fitness check. So we continue evaluating all our laws all the time. But in that digital fitness check, we will in particular look at the intersection and interaction between horizontal data laws, such as the Data Act, with sectorial data laws. Because we understand that this is a problem, and now for the data unit strategy, we didn't have the time to address that properly, but it will be part of the digital fitness check that we will launch then in the digital simplification package later this year. I'll leave it at that, but I mean, I'm sure we'll dig a bit deeper into some of the issues that are raised.
Thank you very much, Björn, for giving us this first overview of what the Commission has in mind. Let me turn now to Francesco to get an industry perspective of what industry would like the Commission to do and how you see possibilities and potential for simplification and streamlining of EU data regulation.
Yes, with pleasure. Thank you very much, Bertin, for inviting and also for your introduction. So perhaps just a few words about Orgalim, just to say from what perspective we are looking at this. So at Orgalim we represent technology manufacturers, as it was mentioned. So these are the manufacturers that are active in the area of mechanical engineering, electronics, electrical engineering, and metal technology. So just to give some examples that, to make it more concrete, these are the manufacturers that are providing the advanced manufacturing solutions for smart factories, like robotics, like automation systems, but they also make the components of the energy grids and the energy plants, and so those are that are enabling the digitalization of the energy sector. But they also do components for machinery and equipment for connectivity. They still work? Yes. For connectivity, infrastructure, and smart warehouses, and so on and so forth. And all in all, these are the manufacturers of all the IoT, so Internet of Things devices that are both in B2B and in B2C. So any connected devices that is inside this room is made by these manufacturers. And so this is why they are the manufacturers of the sensors that are converting the physical variables into digital data. And this is why they are very interested in data legislation, and they are also very impacted by the legislation. And in the last 5-6 years, we have seen quite a surge of data legislation from the EU institutions, and some of them have already been mentioned: Data Act, Data Governance Act. But actually, we see that also in other policy areas there are some pieces of legislation that are impacting the way that industrial data must be managed. To give some concrete examples, I'm thinking of the Cyber Resilience Act, which is introducing new essential requirements on data minimization, both for personal and non-personal data, so going beyond the GDPR. I'm also thinking about the machinery regulation, which for the first time is introducing safety requirements on protection against corruption of internal data. I'm thinking about the NIS2 directive, again on cybersecurity. So the so-called important and essential entities, which are also some of the manufacturers, will have to implement new cybersecurity measures to keep certain data secure, and that also implies changes in contracts in the supply chain. and so on and so forth. Another example is the eco-design regulation, which is introducing a very good idea, actually, which is the digital product passport, which is something that we very much support, because it is going to elevate the way that data flows across the, let's say, the information on the supply chain, across the supply chain, really to another level. That's something that we welcome very much. But also on this side, like in the previous examples, this is really the time for implementation, and we are waiting for quite a lot of delegated acts and implementing acts, so all the secondary legislation that is going to make the eco-design regulation then really applicable on the ground. And there are still a lot of question marks also there. So what are the data that are really going to be included in the digital product passport? That is still to be confirmed. What is the architecture of this? So the IT behind these DPPs. So there is a standardization effort going on this. So there are still a lot of question marks, and because of all these different regulations, and I'm sure that I've forgotten some, we see that all of them are coming really at the same time, and they are impacting sometimes the same businesses or the same business models or the same products. And all of this needs to be considered by the manufacturers, and it is going to cost human resources, time, money in order to implement all of this. This is why we welcome very much the ambition for a simplification that this Commission has, and we call for a pause in regulations. So now it is really the time for implementing the many new rules and to bring them to the market before thinking about new legislation. And coming to the Data Act, let's say it's a complex matter, because actually when we looked at the Data Act at the beginning, when it was first proposed, actually we did welcome very much the intentions, and we think that the objectives are really the right ones: more interoperability, more data availability, less lock-in effects. That is like the dream scenario. So all the objectives are the right ones. When we look at how the Data Act would like to achieve this, that is where in the industry there are a lot of question marks, and actually quite a lot of concerns that it may not play out the way that we would like it to. To give some examples, when we look at the definitions and the way the interplay of the Data Act together with other legislation like GDPR and all the cybersecurity legislation that is also acting on the same products, the framework is really complex, and we don't we feel we don't have all the solutions. There was some guidance, and indeed it was mentioned the FAQ document that the Commission has prepared already helps a lot. There are some other things on the guidance side that are still missing. Standardization is a big part of it, and we know that there are delays. So that is going to make the whole implementation picture quite difficult. And another point on the Data Act is that let's say specifically looking at the chapters 2 and 3 of the Data Act, which are about the IoT data economy. one of the main problems that we see is the fact that trade secrets must be shared, and there is a mandatory data sharing of trade secrets. And there is really a fear that it is going to actually erode trust in data sharing ecosystems, potentially affecting also the data spaces, the nascent data spaces, which otherwise would be a great tool. Regarding this, we really see that as the probably the main pain point in the Data Act. There are some ways in the Data Act to safeguard the trade secrets, but the impression that we have is that they may work on paper, but in reality the thresholds to trigger those safeguards are too high, and de facto they are not going to work out. Just to conclude on this point, we also have actually a question for everybody, and especially for the Commission. On the one side, on the Data Act, we are being told to share trade secrets that are, included in the patterns of sensor data that come out of that are generated by the IoT devices. And on the other side, we keep on hearing from the Commission at all levels, political and technical, that Europe needs to focus on technological sovereignty. So on the one side, these trade secrets may end up in the hands of customers in the best of the cases, but also third parties which may be international competitors in the worst of the cases. On the other side, we are hearing that Europe has to do more on technological sovereignty. And we really wonder how this is going to go hand in hand. We think it is a contradiction. And so one of the recommendations, and I close, for the data simplification is to be ambitious on the Data Act, and restore trust, make sure that the upcoming data spaces and the data ecosystem is trusted, and therefore to keep the trade secrets out of the Data Act scope. Thank you.
Thank you very much, Francesco, for this industry perspective. Leona, let me turn to you now and hear a more academic perspective. You've studied all these data regulations. You've seen where the lack of coherence, the fragmentation in the data market. What would you do if you were in charge and Ms. van der Leyen would tell you, come up with a plan to simplify this? What would you, as an academic, propose?
Thank you very much for the question, and also for the other contributions of the panelists. I feel like you've set me up quite well and you've given me quite the task. But for me, I would start by saying that I am sympathetic to the calls for simplification, but as a legal researcher, I can't help but prefer more the idea of coherence rather than simplification. I understand that the administrative burden is real and the situation is undeniably complex. But when we talk about data, we're talking about fundamental rights, markets, infrastructures, innovation. The situation is complex. And I think simplification risks kind of flattening out some of the necessary nuances. So I prefer to think more of coherence. And it's already kind of been outlined what we have in terms of data regulation. We've seen this expansion with the Data Governance Act, the Data Act, the European Health Data Space Regulation, accompanying, of course, what's already been mentioned, the Digital Markets Act, Digital Services Act, and then, of course, the AI Act. But I would also highlight the fact that this comes on top of kind of legacy legal frameworks that we have, such as the GDPR, the Open Data Directive, free flow of non-personal data, but also intellectual property law, competition law, and consumer law. So for me, the problem is that we have a wide range of legal frameworks that all kind of regulate data in one way or another, but they also understand data quite differently. And as you already alluded to, data is quite unique in this kind of non-rivalrous nature. So I reflect on what we have now as a body of EU data law, and I would say that it's not really a deliberate design as such. Instead, we've seen an evolution of data law. And so now we're having to take stock of what this really means. So along with a few colleagues, we tried to develop a taxonomy of data categories, data types, based on the different legal frameworks. And we found it extremely challenging because we saw that these different categories of data are at different levels of abstraction. Some of them talk about source, other of them are focused on legal status, or maybe also the use or purpose. So we find that the data categories aren't really commensurate of one another, and this isn't just problematic from a research point of view, but practically this makes it very challenging when we try and operationalize these different legal frameworks. These different access regimes talk about kind of different subcategories of data. And to make more clearly, the Open Data Directive is really focused on kind of access to data for public value, while as the GDPR is more individual rights. The Data Act is more about certain market failures and kind of commercial aspects. And then, of course, the European health data space is really more sectorial. So like I said, we see that in some cases, it's about the source of the data, if it's IoT data, health data. Others, it's about the legal status. So is it personal data or trade secret? And again, others, it's about the conditions of use or purpose. Taking into example the text and data mining exception for copyright. So each of these bring their own access regime, ranging from kind of full openness to more closed, confidential. And I would say that the result of this isn't just fragmentation, but it's actual conceptual incommensurability. These categories don't kind of neatly line up with one another, which means that they don't share kind of a taxonomy or a conceptual framework, which makes it very hard to translate between the different regimes. And this is problematic for researchers, for businesses, but also for policymakers. And it's making legal interoperability more and more challenging. And especially in the context of AI, when we talk about data quality and we're looking at kind of lawful access to data, this makes it very challenging because we need to try and combine heterogeneous data sets, but there's so much uncertainty around legal access, permissible use, and then of course, cross-sectorial data sharing. So to get back to your actual question in terms of where we go from here, rather than just outlining kind of taking stock of what we have, I would say that the first step is really to acknowledge this complexity. I think we have to recognize that the legal framework that we have now is complex, but it's complex for a reason. Each kind of legal framework that we've discussed here has a specific regulatory objective. Some of them overlap, some of them maybe challenge one another, but this is really important that we recognize this if we want to move forward with coherence and some attempts at simplification. So I would set as priorities 3 things. One, I think we need to really adopt a holistic lens. It goes back to the point made that all of these legal frameworks are often kind of acting on one single actor and they're having to navigate this. So I think we need some sort of holistic lens so that we're not looking at these legal frameworks in silos, but more at how they work together, where they overlap, where there's gaps, and how we can better fill those. I think it's open to discussion what is the best perspective to adopt here, what kind of lens, whether it's a value-based one, rights-based, something more market-based, thinking of kind of an infrastructure lens. But I think the big point is that we need to look at this in a more holistic manner. And that common lens will help us to identify complementarities and also gaps. So this would help with simplification and coherence. The second thing would really be to take stock of the regulatory toolbox that we have. I think as the EU, we can be proud of the efforts that we've made in data law. There has been great innovation when we think about the regulation that we have. But I think we need to look less at kind of aspirational views and provisions and more at like a diagnostic approach. So really trying to look at what are the actual problems. Do we have the tools to address this? Do we really need more tools? Where can we leverage from, especially across those different kind of legal frameworks that I outlined earlier? And finally, just to reiterate, I really think that we need to focus more on coherence than simplification. This means in terms of legal interoperability, how these frameworks interact with one another, not just from a conceptual perspective, but really also in practice. And I think the likes of the frequently asked questions and the further guidance on the new regulation has been extremely helpful. I think we also need to kind of look at where the different legal frameworks reinforce and support each other, or whether or not they're producing chilling effects on the data sharing economy. So I think here broader frameworks such as, say, competition law, IP, data protection, and even sovereignty and resilience, these really come into play. So we need to try and build bridges between these siloed regimes would be kind of my suggestion for moving forward. But ultimately, I believe that the EU has a really rich and ambitious body of data law, and the challenge, therefore, is not to simplify it away, but to really harmonise it conceptually, but also operationally, so that it both protects rights, but also supports innovation. So I would be putting that forward as my path towards the future.
Thank you very much, Eliona, for your thoughts on this. Björn, let me turn back to you. You've heard from Leona and from Francesco, their views on this. You've also explained what the Commission plans to put in this data union strategy, but if I have understood correctly, there is very little in terms of improving coherence. Well, you talk about simplification of governance bodies and integrating them. That's maybe a step forward. But otherwise, you talk about expanding the number of high-value data sets for AI and about cross-border data flows. I didn't hear you say anything on improving coherence between different regulations. Has the Commission discarded this, or is this somewhere hidden underneath still?
No, I mean, is it on? Yes, now it's on. I mean, first of all, of course, in the data union strategy, we also have other tasks. I mean, yes, this is an important aspect, simplification and coherence, but I mean, making data available for AI is equally important, and so are the international data flows. So we cannot just focus on one topic. I mean, secondly, of course, we can only really speak about the legislation that is fully under our control, and there we try to be more coherent. So we'll probably merge some legislation, adjust definitions that they are, public sector data means the same in the Data Governance Act and the Open Data Directive. So we try to, in the legislation that we control, introduce more coherence. And then I alluded to the digital fitness check, where we will look more comprehensively and systematically at the interaction between horizontal laws and sectorial laws. But even beyond that, I mean, we are also, of course, very interested that the Data Act is the horizontal law when it comes at least to connected IoT devices. And we are in close coordination with all the other Commission DGs and try to anchor everything they are doing on data, of course, in the principles of the Data Act. And just to give you one example, in the Automotive Action Plan, the Data Act was recognized as like the baseline, and this will now be complemented by specific guidance on vehicle data, which we'll actually publish also this Friday. I think that's a good example how it can work. Where there is not a sector-specific legislation on vehicle data, but it's the Data Act, and then we provide some guidance how the Data Act should be interpreted in that specific context. At the same time, and then I think Leonie alluded to that, we have to acknowledge that specific sectors have also specific challenges. If you think of healthcare, of course, where governments have a share of, 60-70%, that requires a different regulatory approach from manufacturing data, for example, where it's completely privately handled. And it makes sense then to have something like the EHDS, where governments have a stronger oversight role to ensure that data is handled properly and compared to other sectors. So it's always a balancing act, of course, to have just like one horizontal piece of legislation that applies across the board, and at the same time also addressing these specificities that you see. I mean, we try our best, but I mean, I also have to admit, of course, we're not always successful. There are inconsistencies, undoubtedly, and we try to iron them out to the extent we can in the package that's coming up, and then we'll take a more systematic look in the digital fitness check.
Thank you. Francesco, you mentioned this trade secrets in the Data Act. Of course, the Data Act was one of the first pieces of EU data regulation that brought up this trade secrets issue. And many people were a bit surprised by this. Everybody likes to protect their own data. Consumers want to have their privacy protected. Companies want to have their data protected. Nobody likes to share their data. Is it really necessary to protect these trade secrets so much? After all, if we want to share data, and if industries want to share and have pools of data available, it's almost inevitable that some of these trade secrets spill over. Why is industry so resistant to that?
Thank you for the good question. So we have to understand one thing. So on when it comes to trade secrets, there is actually a very clear definition under the Trade Secrets Directive, right? So trade secrets is not just a name that one can use indiscriminately and to avoid sharing data. So there are some data sets that can be protected as trade secrets, others that can't. And in order to be eligible for the trade secret protection, they need to fulfill 3 criteria that are set out in the Trade Secrets Directive. The danger when once the data sets are actually fulfilling these criteria, these are usually the data that the manufacturers, and not only the manufacturers actually, but also digital service providers and others keep the most secret, because they are usually those that are making their products or services more competitive than their peers, so than their competitors. So this is what is giving them a certain competitive edge on the market. Right. So and usually, in order to build this kind of competitive edge, especially when it comes to IoT data in B2B and B2C, this is usually the result of years of research and investments and human resources put into them. So this is why they need to be protected, and this is why the manufacturers would be so nervous in sharing them.
Yeah.
To come in there, because I mean, of course, we're aware of these sensitivities, and I mean, we have the trade secret handbrake in the Data Act. You alluded to that, so you can withhold sensitive data in case certain trade secrets are endangered, and serious economic harm is on the horizon. Of course, you can say the threshold is a bit too high, but at least we have this trade secret handbrake. And I think secondly, and that's more important, it's only raw data that's in the scope of the Data Act. And sometimes struggle to understand what the trade secret is, and in particular with raw data. So think of a vehicle. It's like whatever, the speed of the vehicle, that would be in scope. But more sophisticated process data related to predictive maintenance or the range of the vehicle, that's outside of the scope. And this is normally where all the intellectual property work has been invested, because you need algorithms to process the data and get a new output, basically. It's only raw data that's in the scope of the Data Act and not processed data. And maybe the third point is, of course, that re-engineering happens all the time. And maybe this is an unfortunate fact for companies, but I mean, famously, I think, a Chinese company at one point bought a whole airplane from Europe, disassembled it and re-engineered it, and now they are also an airplane manufacturer. I mean, this is maybe a sad reality of our modern economy, but it happens all the time, and I don't even think it's illegal to re-engineer products. I'm not completely sure, but maybe, Leona, you know that. But, I mean, I think that the Data Act doesn't make a fundamental difference in this discussion. Plus, we have, the trade secret handbrake, and only raw data is in scope of the Data Act.
I think this is one of the questions that I have on many of these data regulations, is that they only foresee sharing of raw data, primary data. And why would that be so? Take, for example, the EHDS, the health data space regulation, because there, doctors' analysis of a patient's data and their recommendations, which is, to all practical purposes, in my view, processed data by the medical doctor, also has to be shared. So why not expand these regulations? If I like to do biking, I have one of these digital devices on my bike that track everything I do. But if I want the device to share data with me or to share it with another service provider, I only get the raw data. But I see on my screen the processed data. I've paid for that. So why not allowing me to share these processed data?
Always, I guess, talk to the manufacturer and see whether they would agree to provide that to you. I mean, I'm not sure you always need like a legal base to do that. There needs to be like a legal.
I talked to the Commission on this. So.
Yeah, but and for EHDS, there's also an opt-out. That's also part of the truth. Yeah. So you can also opt out of this sharing of data, of course.
Leona, one last question before we turn to the audience. Björn mentioned this, and you also alluded to this. There's this question of why having many regulations and not one single regulation, possibly with specific technical implementation guidelines in specific sectors and domains, but that would ensure coherence. Of course, we're probably too far advanced in the EU. We already have all these data regulations. We are not going to scrap them and all of a sudden all of these. So, but just from a purely academic point of view, would you be in favor of a single overall regulation? Could the Data Act become an overall regulation for non-personal data while we have the GDPR as a general regulation for personal data?
Thank you. I think, at least from what I see, the Data Governance Act and the Data Act were intended to be those horizontal legal frameworks that really set the baseline, and then the different sectorial common European data spaces would really build on that and try and take into account the sector specificities. I think health is a particularly unique case, as already discussed, and there we see kind of elements of trust and ethics, but also who holds the data being important factors. So I think we need to acknowledge the fact that there are sector specificities, there's different risks, and these need to be taken account into the different domains. But I think for the purpose of horizontal coherence, there is value in having a horizontal legal framework such as the Data Act, and moreover it's then aligning, as you said, the definitions between those and the complementary legal frameworks so that we have this shared baseline. I think that there is a role to play with the kind of strategic sectors of the common European data spaces in that they can evolve based on the needs of that sector. And we've seen that. We've seen very different kind of governance frameworks across the different sectors trying to develop based on the needs, but also on the stakeholders and the different roles they can play there within the governance framework. So to a certain extent, I think the Commission has tried to do that with the Data Act and the Data Governance Act. Of course, as we've discussed, there's certainly room there for improvement, but that is the approach that I generally see, a horizontal legal framework to give this baseline, and then sectorial initiatives or through standards or kind of secondary legislation can support this to address the specificities. One of the most important things we need to remember is that as much as we have these sectorial common European data spaces, the overall goal is a single market for data. So we need to be able to share data across these common European data spaces as well. And there I think a role for horizontal legislation is particularly important to facilitate that, because we're trying to open up access to data that we see siloed in various kind of locations. And we don't want to silo it again in these sectors. We need to make sure that kind of cross data space sharing is possible.
Björn, very quickly before we turn to the audience.
I reply to Björn on the trade secret issue. Well, of course, when you look at data points singularly, there are no trade secrets. So if you look at speed singularly, there is no trade secret there. Usually, at least, it depends on how it is all engineered. The problem especially starts when you take into account the fact with the Data Act, because of all the raw data have to be shared, there are patterns of data that will become visible to the receiving sites. And the trade secrets usually are in the patterns. So the data taken singularly doesn't usually count very much. The context is what is making data rich. Even if it is raw data. So when it comes to give an example, take a smart engine. It is the combination of the data points in different sensors like pressure, volume, temperature, and so on, acting all together at the same time. That is going to trigger perhaps different behaviors of the engine. So with retroengineering, usually these data points are not visible. You can see, you can disassemble the engine and see the sensors. Maybe you can figure out what kind of data is produced, but you cannot see the pattern. because the pattern is you can see it only when you get the data. Another example is magnetic scanners in hospitals, for example. So it is depending on the frequencies of the data that is coming from those scanners. There you can have an idea on how the different sensors can communicate with each other. That is where the trade secrets are. And which should be, all the strategies that we are seeing want European companies to innovate more, to do research, to manufacture in Europe. And on the other side, we are saying, okay, at the end of the day, once you have innovated, once you have done a lot of research, well, you have to give up all that research to your international competitors. That's not the message.
I'm sure we can debate for a long, long time on trade secrets and data. Let me turn to the audience and take a few questions on these issues. I also have one online question so far, which is on security, actually, on cybersecurity. And the question is data localization, will it threaten a state-of-the-art cybersecurity technology? And some governments have included cybersecurity exemptions in data regulation. And so could this be addressed in the data union strategy? But before you answer, questions from the audience, please. Yes, please. Is there a microphone available? Over there.
Yes. Hi, hello. Liam McLaughlin, UK Mission to the EU. So thank you very much for the panel, but I was hoping to maybe hear a bit more from Bjorn about, you mentioned national sensitive data and alignment with third countries. I'd be really interested to hear a little bit more about where the work on that still needs to go and what still needs to be done and kind of the scope for cooperation there.
More questions? Yes, please, here.
Thank you, Friedrich Lucke from the European Commission. I was just wondering that if we create these big data spaces where companies fill in data and it becomes relatively accessible, but aren't there also risks that malicious actors could try to pollute our data spaces with faulty images or something like this that would not actually help our research and innovation, but we're making ourselves vulnerable to someone who's trying to deter us from innovating or making progress in certain things. What are the risks that we're exposing ourselves to by creating these very open data spaces?
And there was one more question there.
Sergei Kasyanov, Harvard Aerospace and Defense Alumni Organization. As we know, recently United States stopped cooperation on counter-propaganda fight with European Union countries. How it will impact functioning of European countermeasures against propaganda activities from some hostile dictatorship states? Thank you.
That's maybe a little bit outside the data regulation space, but okay. One last question over here, and then we turn it back to the panel.
Ferdinand Wegener, Siemens. Thank you very much for the panel. I was questioning the approach of saying we either need cohesion or simplification, or one is more important than the other, because for me that's not an either or question. It's more simplification might make a law less administratively burdensome, while the cohesion, I think, is a nice idea to incorporate all the laws into one more cohesive package. But then on the other hand, you said there's different sorts of data that also need different definitions, so that kind of speaks against the possibility of actually having a cohesive approach, especially if different sectors do have actually very different ideas of what they want for their regulation. So yeah, maybe you could speak on that about simplification versus cohesion. Thank you.
Who wants to respond to those questions? Bjorn?
I can start. I mean, I don't fully understand the question here online about cybersecurity, I must be honest. Is the concern that you don't have then the latest data to train state-of-the-art cybersecurity solutions, I guess. I'm not aware of these exemptions, but I mean, for the moment, It's not planned to address this in the data union strategy, but maybe I misunderstand the question. On the question on sensitive data, I mean, we are now really in the scoping phase of that, I would say. So it's very early days. So what data could be in scope, what measures could be considered. It will be a long journey. So it's nothing that, will be ready on day one. It's more like a long journey. And I'm sure there are opportunities then also to discuss these questions with our partners outside the EU. On the data spaces, your question, whether they could be polluted, they're actually not super open. I mean, they are quite strict, access restricted. The cancer image data space I mentioned, it's, I don't know how many, like 34 hospitals in Europe, and that's it. I mean, they have a very sophisticated onboarding process. So, I mean, they make sure that only players with benign intentions participate. It's not that you have a data space and everybody can participate and suck up data. It still has a lot of policy rules, basically, who can access data, who contributes data, in which formats and so on. So they are not open. So in that sense, I think this problem is not a problem in reality. And I cannot really comment on the question on propaganda. That's, I think, a bit outside the scope of the discussion.
Francesco, you would like to say something?
Maybe just quickly follow up on the data spaces issue. Indeed, I fully agree. The data spaces are not supposed to be just a data lake. They are more complicated than that. They are usually a set of protocols and standards that are commonly agreed across all the participants and the stakeholders, and used to share data. Then following those, and just want to add here that the data spaces for manufacturing, which are also we know an important piece of the strategy of the European data strategy from some years ago. There are some initiatives already going on at industry level. So there are a lot of manufacturers and data service providers are working to develop these data spaces, and actually cybersecurity is one of the many things that they are looking at, along with then data legislation and how to make the whole data space work. So data spaces are actually at the crossroad of all these different things that we are talking about: cybersecurity, data legislation, data availability, protection, and so on and so forth. So just one message: they still have some development to undergo, but especially there need to be a lot more awareness on the business cases for to take them up. And this is why we think it is important that they are a part of the data union strategy going forward.
Leona, there was one question that was particularly for you, I think, on this trade-off between simplification and coherence.
Just to confirm, I also agree with the discussion on data spaces. Indeed, they have quite complex governance frameworks, and each kind of develop their own. There are some commonalities, but most actually evolve to try and address the needs and also serve the different stakeholders in that sector. So we see that there isn't so much a risk of them being these kind of open pools, but rather there are these onboarding mechanisms. So I would agree with my panelists there. And indeed, thank you for the question. So just to clarify that the point I'm trying to make is that simplification, I think, is a noble goal, but it shouldn't be our singular focus as we move forward with the data union strategy. I think instead we need to prioritize coherence, because simplifying for the sake of simplifying, I think, has the risk of flattening the nuances and the complexities. As you already pointed out, different sectors have different subcategories of data and have different concepts. And I think through coherence, I don't mean to kind of harmonize this across everything. Instead, I think what we need to do is acknowledge this complexity and then actually clarify the interfaces between these different concepts of data and between the different legal frameworks. And I think by doing that, developing more coherence in this way of clarification, interpretive guidance, we will simplify the legal frameworks, especially if you think about the actor that, as was already pointed out, has several legal frameworks that apply to them. By better showing how these relate to one another and what that actor really needs to do to comply, I think that will bring about some simplification, but instead we're doing it through the lens of trying to develop coherence. So I really put it there as a priority, but I am sympathetic to the need for simplification. but I would just advocate that we do it by trying to develop more coherence. I understand that it's even more challenging when we look at legacy legal frameworks and how we really bring better coherence there. But at least in these digital packages that we have now, I think we can do more to harmonise definitions where we can and clarify interfaces. And so I am very hopeful at this idea of a digital fitness check and what this could bring about.
We are coming to the end of this panel. Thank you very much, panelists, for your contribution to this debate. And thank you very much to the audience. And hope to see you all back at other Bruegel events in the future. Thank you, and have a good afternoon.